provision is in consonance with Article 291 of the Labor Code, which states that the terms and conditions of employment of government-owned employees, including those of government-owned or controlled corporations with original charter, shall be governed by the Civil Service Law, rules, and regulations. The law and rules of the civil service do not allow strikes.
It should be remembered that what the Constitution guarantees is the right to strike in accordance with law. A reasonable interpretation of the phrase "in accordance with law" in relation to the right to strike is that the said right may be exercised only when and where the law allows it and in the manner, and upon compliance with the procedural requirements prescribed thereby.
Moreover, in the case of SSS Employees Association versus Court of Appeals, the Supreme Court ruled that on the basis of the record of the proceedings of the Constitutional Commission that drafted the 1987 Constitution, the intention was to grant government employees the right to form unions but not the right to strike.
Court stated further that since the rule both under the Industrial Peace Act and the Labor Code is that the terms and conditions of government employment are fixed by law, government workers cannot use the same weapons employed by workers in the private sector to secure concessions from their employer.
In the case of Jacinto versus Court of Appeals, the Supreme Court distinguished between the right of public school teachers as employees covered by the Civil Service Law to assemble peacefully and to petition the government for a redress of grievances and absenting themselves from their schools during days without proper authority in order to participate regular school in a mass protest. The court said, had petitioners availed themselves of their free time, recess, after classes, weekends, or holidays to dramatize their grievances and to dialogue with not the proper authorities within the bounds of the law, no one, not even the Department of Education, Culture and Sports, the Civil Service Commission, or even this court could have held them liable for the valid exercise of their constitutionally guaranteed rights. As it was, the temporary stoppage of classes from their activity necessarily disrupted public services, the very evils sought to be forestalled by the prohibition against strike workers. Their act by its nature was enjoined by the civil service government by law, rules, and regulations for which they must therefore be held responsible. The court also ruled that, as regards the right to strike, the Constitution itself qualifies its exercise with its proviso in accordance with law. This is a clear manifestation that the state may, by law, regulate the use of that right or even deny a certain sector such right. The strikers were punished with suspension and ordered reinstated without back wages. Number 6, it is well settled that an economic strike declared in violation of a no-strike clause in the CBA is illegal. An economic strike, it will be recalled, is one whose purpose is to force wage or other economic concessions from the employer which he is not required by law to grant. It refers to a strike grounded on a deadlock in collective bargaining. The Supreme Court has somehow vacillated on this issue. In the case of Philippine Metal Foundries versus CIR, the court ruled that a no-strike clause in a CBA applies only to an economic strike, not to a strike based on ULP committed by the employer, even if it turns out that no ULP was actually committed. However, in the case of GOP-CCP Workers Union versus CIR, the court in effect reversed Philippine Metal Foundries by holding that a stipulation in the CBA that, in case of unfair labor practice on the part of either party, there will be no strikes, lockouts, or any prejudicial action until the question or grievance is resolved by the proper court if not settled through a grievance procedure therein outlined, was valid and binding, and that the strike held against such an agreement, considered to be an exclusive arbitration clause, was illegal. This ruling was reiterated in Ilaw at Buklod na Manggagawa versus NLRC. But in Master Iron Labor Union versus NLRC, the court, citing Philippine Metal Foundries, ruled that a no-strike clause in a CBA applies to economic strikes and not to strikes founded on unfair labor practice. It has been held in this connection that a no-strike stipulation in a CBA is a personal undertaking of the contracting union, so that in case of a change in the bargaining agent while the CBA is subsisting, the same need not be assumed by the new representative even though the substitutionary doctrine provided otherwise. This rule finds more urgency today in view of Associated Trade Unions versus Trajano, where it was held that a CBA that was concluded after the filing of a petition for certification election may be rejected and replaced in case the challenger emerges as winner in the election over the former incumbent agent which entered into the CBA. The stoppage of work that attends a strike or lockout due to the worker's concerted withdrawal from work in the case of strike or the employer's refusal to provide work in the case of lockout is intended to be temporary and does not automatically sever the employment relationship between the strikers or locked out employees on the other hand, and strike-bound or locking out employer on the other hand. That relationship, or more precisely, the effects thereof, are merely suspended for the duration of the strike or lockout. Whether or not such suspension will become actual termination, especially in the case of a strike, depends on the issue of legality of strike itself or the acts committed in furtherance thereof.